Hi friends, I am your friend Advocate Namish Nigotia and you are watching my YouTube channel Legal Advice for Everyone. Friends, in today's society, matrimonial disputes are increasing day by day. Sometimes what happens that only after 7 days of marriage, husband or wife approaches to the lawyer and requests that they want to seek degree of divorce. When they come to know that they have to wait for a period of 1 year because as per section 14 of the Hindu Marriage Act, no petition can be filed before a period of 1 year in the family code. So they became depressed. What is the reason that husband and wife are not living together? Why the matrimonial disputes are increasing day by day? So subject to my understanding, lifestyle has been changed. There is more influence of social media, less moral values, and every person, either husband or wife, they became egoistic. So in this video we will learn that family court does not grant at first instance degree of divorce. They initiate conciliation proceedings between the parties through a mediator, and if the mediation fails, even if the mediation fails, the family court has power to initiate conciliation proceedings with the consent of the parties. We would like to learn in this video what is section 23(2) of the Hindu Marriage Act, what is section 9 of the Family Court Act. Before I proceed further with this video, I would like to request that if you have not subscribed my channel, please subscribe my channel, and if you like my videos, please share my videos. What section 23(2) of Hindu Marriage Act says? It says, I would like to read: before proceeding to grant any relief under this act, it shall be duty of the court, in the first instance, in every case where it is possible so to do consistently with the nature and circumstances of the case, to make every endeavor to bring about a reconciliation between the parties. Supposingly, what does it mean? It means that whenever a party, either husband or wife, approaches to the family court for seeking degree of divorce, it is the duty of the court, the word duty has been used, duty of the court to make every endeavor to bring about a reconciliation between the parties through a mediator. Some experts from society came and they initiate mediation proceedings between the husband and wife, and they make them understand that they should not leave the matrimonial home. They should be live like husband and wife, and every dispute arises between them should be dissolved and it should be end. Now we would like to learn what is section 9 of the Family Court Act. It also says in the same tune. I would like to read subsection 1 of section 9 of Family Court Act. In every suit or proceeding, endeavor shall be made by the family court in the first instance where it is possible to do so, consistent with the nature and circumstances of the case, to assist and pursue the parties in arriving at a settlement in respect of the subject matter of the suit or proceeding, and for this purpose a family court may, subject to any rules made by the High Court, follow such procedure as it may deem fit. It also says that at the first instance, at the very beginning of the trial, the court shall make endeavor for reconciliation between the parties. The sole purpose of the Hindu marriage, because you know that Hindu marriage is a sacrament, it is not a contract. So the sole purpose of Hindu marriage, that they should live unitely like husband and wife. They should not be separate, and the degree of divorce only be granted after the extraordinary circumstances, extraordinary disputes arises between them. The whole society, the legislature, the acts made by the legislature and the courts used to do conciliation proceeding. I would also like to read subsection 2 of section 29 of Family Court Act. If any suit or proceeding at any stage it appears to the family court that there is a reasonable possibility of a settlement between the parties, the family court may adjourn the proceedings for such period as it thinks fit to enable attempts to be made to effect such a settlement. What does it mean? In any it says in any suit or proceeding at any stage, not at the first instance, not at the first stage, not at the stage of summoning, filing evidence, at any stage, even after the final arguments done by the parties, the court can initiate the mediation proceedings. Now the question arises that whether the parties can make application. Yes, of course, either husband or wife can also move an application that there is a possibility of settlement and the dispute can be resolved through the settlement and the matter should be sent to the mediation proceedings. How to draft the application for settlement? Name of the court first, name of the court, whichever the family court may be, then cause title, name of the husband or wife as an applicant and name of the husband or wife as a non-applicant. Then they should state that the marriage has been solemnized on such and such date as per the Hindu rituals, as per the Hindu Marriage Act. Then they should state that the dispute arises because of the confusions between the parties. Then they should state then there is possibility that the dispute can be resolved and the institution of marriage can be saved. Then they should mention that the matter should be referred to the mediator and for conciliation proceedings. Now the question arises, what are the very important judgments of Apex Court in this regard? So Apex Court, the title of the citation is Jagraj Singh versus Birpal Kaur, 2007, 3, Supreme Court 389, reported in JT. It says, may I read? The Act, Hindu Marriage Act 1955, is a special act dealing with the provisions relating to marriage or divorce. Subsection 2 of section 23 expressly states that where a petition for divorce is filed under section 13 of the Act on certain ground, before proceeding to grant any relief, the court in the first instance should make an endeavor to bring about reconciliation between the parties. It also says that before granting degree of divorce, the court should make an endeavor for reconciliation between the parties. Now, other important judgment of the Supreme Court of India is K. Srinivas Rao versus D. A. Deepa, 22nd February 2013. It says it has issued certain directions to all the family courts. So I would like to read. We therefore issue directions which the courts dealing with the matrimonial matters shall follow. In terms of section 9 of the Family Court Act, the family court shall make all efforts to settle the matrimonial dispute through mediation. Even if the consular submits a failure report, the family court shall, with the consent of the parties, refer the matter to the mediation center. In such case, however, the family court shall set a reasonable time limit for mediation center to complete the process of mediation, because otherwise the resolution of the dispute by the family court may get delayed. So it also, Supreme Court has issued the guidelines that even if the mediation fails, after getting the report of the mediation officer, the family court can initiate the proceedings for reconciliation. It further says the criminal court dealing with the complaint under section 498A of the IPC should at any stage, and particularly before they take up the complaint for hearing, refer the parties to mediation center if they feel that there exists elements of settlement and both the parties are willing. However, they should take care to see that in this exercise rigor, purport and efficacy of section 498A of the IPC is not diluted. It further says all mediation centers shall set up pre-litigation desk clinics, give them wide publicity and make efforts to settle matrimonial disputes at pre-litigation stage. So friends, in this video we have learned what is section 23(2) of the Hindu Marriage Act, what is section 9 of Family Court Act, and how the court used to do conciliation proceedings before granting degree of divorce. Thank you so much, friends.